All right, it's 2:01, my friends. Thank you for joining us today for a webinar on Section 230 and Trump social media executive order. So the way we're going to do today is we're going to walk through the 230 EO and have each person provide a perspective. And with that, I'll turn it over to Professor Keller from Stanford. Thanks.
Thanks a lot, Andy, and thanks for having me here. I think the reason I'm on this panel is that when the EO first came out, I did this annotated version of it in Google Docs that a lot of people have been using as a reference. And since doing that, I haven't been deep on the details of the things like this sort of agency roles in the way that I bet a lot of people in the room have been. So I'm really looking forward to hearing what other panelists and maybe audience members have to say about that. But in that annotated version, I used color coding, really bright color coding, for which I apologize. In the color coding, red meant this text is largely rhetoric and atmospherics without direct legal consequences. And there's a lot of red in there because there's just a lot in the EO that does not have direct legal effect. That said, in the real world, people react to things other than laws with legal effect. And so we should be thinking hard about whether the sort of hand-waving parts of the executive order are having real impact on the choices that platforms make about user speech. So in those sort of more rhetorical portions, there are two big points that are both really important. Like they're both things we should be talking about in the public conversation, regardless of what we think of the executive order. So the first one is something that I think actually resonates across the political spectrum, which is concern that very large platforms are acting as gatekeepers for public discourse. They're shaping what people can say, they're shaping what access to information people have, and therefore there is a real public interest in understanding and ... maybe controlling through laws what it is that those gatekeepers do. In the US, this has been seen as a conservative issue because when conservatives are on the losing end of this, I think they've done a very good job of getting media attention to it. So that's what gets a lot of reporting. But Black Lives Matter organizers have complained that they think they're the victims of unfair takedowns. Muslim rights organizations, gay rights organizations, there are people all across the spectrum and all over the world who are raising the same concern. Sorry, is my audio messed up? I'm seeing a comment suggesting it might be. So if there's anything I can do.
It's not as bad as Andy's was, and so I think it would be, you should just continue.
Okay, will do. The second sort of big rhetorical point in here is also something that warrants genuine policy discussion, which is like, well, maybe if we still believe platforms are private entities and should get to make their own rules, their own editorial policies about the speech that they host, we nonetheless want to have this sort of consumer protection approach that says they have to be really clear with their users about what the rules are. They have to enforce them fairly and can be challenged if they don't. Have appeals, have maybe a public enforcement body to say whether they are enforcing their own rules, fairly and being transparent about what those rules are. That one, also to be clear, is a rhetorical point, not an enforceable point in the executive order. But that's also something where there's interest across the political spectrum around the world in whether that is a workable way forward. There's some real questions about it, right? Like realistically, if you set up a government agency to decide what's a neutral or fair or accurate interpretation of platform speech rules, that government agency is likely to bring its own political agenda to the table. That was Republicans' complaint about the fairness doctrine in the FCC for, a generation or two. Also, there's a question of like, what would it even mean to have a government agency oversee this? Are we saying that all of the millions, I think, of appeals against Facebook takedowns, they all go to some staffer at the FTC? What is the staffing for that? So there's some real questions, but those are the most interesting and big rhetorical points. Now, moving on to the legally enforceable, like actionable pieces, there are two big things that sound consequential, but are really just recommendations to agencies who don't necessarily have to follow them. The first is for the Federal Communications Commission, the FCC, to endorse a legal interpretation of CDA 230 that is pretty unsupported by the courts or by the statute. This is an interpretation that takes the good faith provision at 230 C2, C2A, and imports that into the rest of the statute as a requirement. The second sort of agency referral piece is saying that the Federal Trade Commission, the FTC, shall consider prohibiting terms of service misrepresentation. So they'll sort of use their unfair and deceptive standard to bring this, what I described as consumer protection approach to making platforms enforce their terms of service fairly and accurately. Then there are, moving on from those sort of two things that sound really consequential but might not be, there are three things in the executive order that sound inconsequential but that I think might be a big deal. One is saying that federal agencies shall adopt this interpretation of CDA 230 that I just mentioned, the one that takes a good faith standard and exports it to parts of the statute where it does not appear. I think there will be people in this room with better insights into what that means. Like, what are these opportunities where agencies do something to do with CDA 230 where this standard will matter? You know, are there civil DOJ actions where this matters, et cetera? Second thing that sounds maybe inconsequential but might be a big deal is that the DOJ is supposed to convene state attorneys general to look at a long list of potential complaints and use anecdotal reports of bias takedowns that come in through the White House's tech bias reporting tool as sort of fodder for those inquiries. And then the third one, and this one I'm actually quite concerned about, says that the Justice Department is going to review which platforms are, quote, problematic vehicles for government speech due to viewpoint discrimination, unquote, and use that in an exercise to figure out who should be carrying federally funded ads. So that might be a big deal to some platforms if they get a lot of ad money from federally funded ads. I doubt there are too many platforms in that situation, but it's a very big deal at a macro level because it is a government-created blacklist, essentially. You know, it is a list of the bad companies whose editorial policy is wrong, and who should therefore be cut off from ads, but maybe also you just might want to avoid them generally because they are the bad guys. I mean, this feels very McCarthy era reminiscent to me. So those are the sort of working pieces of the executive order. I do want to pull back to the rhetoric point again, because I mean, imagine just in the real world for a minute, if you are a content moderator or even the CEO deciding what to do at any kind of a platform, at WordPress or Medium or Etsy or Craigslist or the New York Times comments section or, you know, the Seattle Strangers comments section, wherever, and you're looking at a post that's very offensive, or, you know, looking at an account from the next Alex Jones and deciding whether to take it down. If you do take it down, maybe you wind up on this blacklist. You know, maybe you wind up the object of this kind of criticism from powerful government actors working outside of the legislative process. If you don't take it down, then you can avoid that. You know, you can avoid this legal consequence and also avoid having your, you know, comms and policy team have their life dominated by this dispute for the next several months. And the easiest thing to do is to not exercise your preferred editorial policy and just do what the White House wants you to do. And that's kind of the definition of a chilling effect, right? So I know Emma's going to talk about that later, but I think looking at this in terms of what happens in the real world for real platform employees making individual decisions is the right way to come at this. Thanks, Andy. I yield my time.
Excellent. Thanks, Daphne. I'll just let everybody know we've got a Q&A chat screen there, and if folks want to add in their questions, we'll get to them as soon as our panelists have done their opening statements. And with that, I'm going to send it over to Evan, the Executive Director for Engine Advocacy.
Thanks, Andy. Thanks for having me. For folks who don't know Engine, we're an advocacy organization, or a research organization that works on behalf of the startup community. Many of the startups we work with rely on Section 230. The breadth of companies out there that depend on its protections is really almost limitless. And what's troubling about this executive order and a lot of the purported attempts to reform Section 230 across the political spectrum are most of them are predicated on a strange myth that has persisted, which is Section 230 is from the 90s. It was created at a time when the internet was in its nascency, and now look how powerful these internet companies are. We don't need Section 230 anymore. Putting aside the question of whether you think the specific companies mentioned in the executive order need Section 230, and to remind folks who those are, I think we already know, but it's Twitter, Instagram, YouTube, and Facebook. The EO mentions 4 companies as though this were the entire breadth of the internet. Maybe they need Section 230 as well, but they certainly need it less than the vast range of companies online that depend on Section 230 to survive. And the reason it's so critical for smaller platforms is it is basically a bulwark against vexatious litigation that will inevitably pop up when people disagree with your content moderation decisions. I think this executive order is an emblematic example of how that plays out. Somebody does not like the way Twitter has decided to regulate speech on its platform and has used, in this case, sort of extrajudicial methods for coercing Twitter into compliance. But buried in this is this threat of we will disrupt the balance of Section 230 in a manner that is supposed to foster more online discourse, more diverse viewpoints, when in reality, all it's going to do is cement the power of those 4 companies that were named. And the reason is relatively clear. Section 230 allows platforms to dismiss at an early stage in litigation claims predicated on user speech. So there's simply no way, even for small platforms, to perfectly moderate the enormous range of content that appears on their sites. Companies try to do it. They spend a lot of time and money relative to their budgets and their staff to deal with this sort of stuff because they want to foster valuable spaces. Particularly smaller companies that need to compete with these larger entities want to make sure that their platforms are valuable for users. And a big part of that is making sure that the online discourse is safe, it's relevant, it's consistent with the values that their users espouse. And so it prevents sort of individual lawsuits from bankrupting these companies. This is the whole reason Section 230, or in large part, was created, was in response to this threat of litigation for being unable to perfectly moderate content. And so what troubles me about what the EO is attempting to do, and I think it's important to note that it is legally dubious in this regard. It's trying to reframe how people should interpret Section 230, when in reality that is a job left for courts and for Congress, effectively, if they want to sort of redesign the statute. But what it basically says is, we'll try to deprive Section 230's protections from companies that make moderation decisions in not good faith or bad faith. Why that's troubling is, beyond the impossibility of making that determination, you now lose Section 230's value as a way to get rid of bad faith claims early on. Imagine I'm some random internet troll and I don't like the way Twitter is moderating content, or say, the way a smaller platform, a Patreon, is moderating content. What's to stop me from just filing a lawsuit saying, I've been defamed, I have, there's some harm that's accrued to me here. Normally, that website is going to be able to assert Section 230 on a motion to dismiss. Get rid of the case before you have to go through discovery. Get rid of the case before you have to spend a ton of money defending yourself against what is ostensibly a meritless lawsuit. The changes that this executive order would purport to bring upon Section 230 would make that impossible. It would make lawsuits chilling speech really, really effective, because now you wouldn't be able to get rid of these cases early on. It would have to go to a court to determine whether your content moderation practices were made in good faith, whether or not you espoused a policy that was, antithetical to the, conservative viewpoints, what have you. That's not something that's going to be able to get rid of, get dismissed early in a case, and it drastically increases the cost of litigation. The reason that's important to startups is startups are the ones with limited budgets. YouTube, Facebook, Instagram, they can afford to do that type of litigation. They can afford to get rid of a bad faith lawsuit targeting obvious parody or obvious commentary. A startup can't. A single lawsuit could potentially bankrupt them. We see it all the time. Beyond that, I think it's important to just note, even though this is not legally enforceable in a lot of ways, at least as it relates to the changes that it would want to make to Section 230, it does create problems for smaller platforms who now have to make a decision about whether or not they engage in the type of content moderation that's going to make them more valuable to users and potentially allow them to compete with larger platforms. So what the EO does is it wants to establish a regime that increases the cost on basically everybody in the internet ecosystem, but falling disproportionately on the smaller players that could theoretically compete with the 4 larger platforms that it mentions. And it limits these platforms' ability to engage in beneficial content moderation that would allow them to compete with these large players. So while it says it's designed to foster and protect diverse viewpoints in today's digital communications environment, it does the exact opposite. The end result of this is it will diminish diverse viewpoints. It will diminish the number of platforms that people can use to have their voices heard. Digging a little deeper, it also has this weird problem that a lot of legislation has that's designed to Section 230 is, Section 230 is being used as sort of a cudgel here. It's not really the problem. Like, take, for example, Trump's tweets that drew his ire. If Section 230 didn't protect Twitter's response to those tweets, what would be the outcome? What would be the action? Section 230 protects companies against civil liability and state criminal liability. That's it. There would still need to be a cause of action that Trump would be able to bring against Twitter for putting a fact check on its tweet. It's unclear to me what that would be. And in most circumstances, when people are complaining about biased perspectives from platforms, there isn't really a cause of action that's obvious to me that people would be able to pursue against these companies. In other circumstances like defamation or CSAM or the many varieties of problematic online speech that might arise on these platforms, the cause of action is a little more obvious. But in the context of anti-conservative bias or purported anti-conservative bias, it's unclear to me what the actual harm is that's trying to be addressed, or that Section 230 is preventing redress from taking shape to deal with. So in that sense, 230 is always something of a red herring in these cases. And it's a way to say, we don't like what you're doing broadly. Let's take away this thing that allows you to survive. You could just as well replace Section 230 in the executive order and say, like, we're going to just impose an enormous tax on these companies if they don't engage in the type of content moderation we like. It's not super relevant to what's going on. As to the other stuff, whether the FTC should be engaging in content moderation questions using its Section 5 authority, that is certainly relevant. The FTC has already recognized that it has the power to examine whether or not platforms are abiding by their content moderation policies in a manner that would potentially become an unfair business practice or a deceptive practice. They've said they have this power. They have declined to use it so far, and I think part of the reason is it's not clear what the consumer injury is. It's not clear whether any of these things constitute violations of those statutes, whether that's at the federal level or at the state level. But it is certainly an avenue that could be explored and is concerning because, again, it puts platforms in a difficult position of having to expend a lot of money defending their content moderation decisions. And all that does is tip the scales in favor of the larger platforms that have the legal budgets and have the resources to deal with this sort of stuff. With that, I will pass it along.
Thank you, Evan. And I must say, I appreciate your music studio and your podcasting studio there. That was excellent.
Hope the audio is good.
Very, very good. So thank you, Evan, for the perspective from the startups. With this, I'll move over to Emma, our colleague from the Center on Democracy and Technology. Thank you.
Great. Hi, everyone, and thanks for having me here. My name is Emma Llansó. I head up the Free Expression Project at the Center for Democracy and Technology. CDT has been around for over 25 years, fighting for civil liberties and human rights online. And our free expression work has involved a lot of active engagement in all of the legislative and policy debates around Section 230. But we also do a lot of work around the First Amendment and kind of fundamental rights protection for speech online. And that's actually really the context in which we're looking at this executive order. I think Evan just mentioned 230 is kind of a red herring in this executive order, and I think we really agree. we're really looking at this executive order as an example of the president trying to coerce social media companies into regulating users' speech according to the president's own desires. This is actually an enormous problem under the First Amendment. So we filed a complaint against the executive order in court last week, arguing that this executive order is an unconstitutional effort to retaliate against social media companies and to coerce them into moderating their user speech in a way that the president sees fit. You've already heard a lot about what's in the executive order, so I'll just briefly describe what's in our complaint. We argue essentially that by issuing the order, the president is attempting to use threats of retaliation and future regulation to coerce social media companies into changing their content moderation efforts related to election interference, voter suppression online, and potentially anything else that the president or any number of federal agencies considers to be viewpoint discriminatory. There are kind of two main issues that we see with the executive order that we address in our complaint. One is that it is clearly directly retaliatory against Twitter in particular, but also more fundamentally that it aims to curtail and chill constitutionally protected speech of all online platforms and of all individuals by demonstrating the willingness of the president to use whatever authority he can find to retaliate against those who criticize the government and frankly who criticize the president directly. As far as the retaliation point, so I think it's pretty obvious to everyone that social media has been a major battleground for disinformation, and it was a kind of a key feature of the 2016 US presidential election. Over the past 4 years, many online services have introduced and strengthened rules against mis and disinformation, against things like coordinated inauthentic behavior, voter suppression, hate speech, harassment, political ad transparency, and incitement to violence. There is a lot of activity that goes on as far as content moderation on platforms of all sizes. The president issued the executive order shortly after Twitter, for the first time, appended a label to 2 tweets that the president had posted, asserting that California's mail-in ballot initiative would lead to massive voter fraud. The label invited users to get the facts about mail-in voting and linked to external resources analyzing the president's claim. And I think it's really important to underscore the president's tweets were not removed. What was added was speech by Twitter and links to speech by third parties. Now, in response to this, the executive order was issued, and the order, as Evan just mentioned, names Twitter and several other social media services. President Trump has also been very clear in his own commentary on Twitter that the executive order is very much aimed at exactly the kinds of things that Twitter was doing. But as noted, there are other companies mentioned directly in the order, and the kinds of things that it proposes would indeed affect all online services, all intermediaries, be they search engines, content hosting platforms, access providers, remote hosting services, everybody who is currently protected by Section 230. As far as the systemic effects that we fear the order will have, the kinds of speech and content moderation decisions that we see social media platforms engaging in when they do things like combat voter suppression, these are editorial judgments that are protected by the First Amendment. And as Evan and Daphne have discussed, Congress designed 230 precisely so that online services can moderate the user-generated content that they host, free from fears of litigation. The threat of litigation has a known chilling effect on content hosts' ability to moderate content and their willingness to host potentially controversial speech, including speech that's critical of the government. The processes described in the order would circumvent the role of Congress and the courts in drafting and interpreting Section 230. As Daphne explained, the executive order imagines a role for the FCC and a new interpretation of longstanding court doctrine about what Section 230 means. And the effect of this, at the very least, is to try to cloud the legal landscape around Section 230, to cloud the legal landscape that intermediaries have depended on for being willing to host user speech. The risk that intermediaries will no longer have the legal certainty that they've depended on to host and to moderate user content itself will creates a chilling effect. on our ability as individuals to access platforms that will host our speech, that will provide places for us to communicate and organize, to connect with other people. The executive order also puts multiple government agencies, including the FCC, the DOJ, and the FTC, and state attorneys general, into the position of passing judgment on companies' content moderation practices. Daphne was mentioning it introduces this concept of essentially a Department of Justice blacklist for federal advertising funding being allocated to different kinds of platforms, depending on what the DOJ thinks of their content moderation practices. In our complaint, we don't really get into the relative merits or legality of any of these component parts of the executive order, but our point is that the whole litany of regulatory concepts that are presented in the order demonstrates the president's intent to throw every conceivable thing that he can at speech that he disagrees with. The order as a whole is designed to coerce social media companies and other content hosts into making only government-approved content moderation decisions. The free speech rights of everyone in the US depend on having access to a diversity of online services and other intermediaries who can operate free from this kind of government coercion. Fortunately, the First Amendment exists, and it is designed to protect us from exactly this kind of coercion. It prohibits government officials from retaliating against individuals for engaging in protected speech. It prohibits government action intended to chill protected speech, and it prohibits governments from trying to suppress lawful speech by going after intermediaries with threats and reprisals. So we think it's really important. I know Evan was mentioning thinking that parts of the order might be legally dubious, but we think the order as a whole is also something that needs to be reviewed by courts, and we think that the court should find that the order as an act itself is is much more than a single step too far, but as a whole, an incredible kind of effort by the president to suppress speech and to shape how people can use online services in our country, and that's not something that the First Amendment allows.
Thank you very much, Emma. That was an excellent explanation of everything going on from your side. Thank you. 2 quick points. We're continuing the conversation on Twitter right now with the hashtag Section 230. And also, I apologize if you hear the sound of a pterodactyl from my house. I have an 8-month-old daughter who is upstairs and very, very loud. I'll just make kind of 2 quick points here. The first is looking forward, how does the social media EO affect the congressional landscape? I think in general, up until a month ago, you saw nearly every member of Congress looking at 230. You saw avenues of reform coming from the House, from the Senate, chairmen, ranking members. There's a concerted effort right now from the Senate Judiciary Committee in a bill called the Earn It Act. There's a lot of consensus among Capitol Hill staffers and members that Section 230 should be looked at, if not wholesale reformed. I think some of the ideas that are put forth in the EO have been reflected in conversations on the Hill, and now by Trump putting out this executive order that's able to target certain pieces, particularly the UDAP provisions of the FTC, in a way politicizes an environment that was relatively bipartisan before. And I think it'll be interesting to see how that plays out for the remainder of this Congress and next. But I think in a way it does complicate efforts for folks that believe Section 230 should be wholesale reformed immediately. And then with that, I guess I'm just going to turn it over to Joe, our final panelists from the Internet Society, to give his perspective, and then we'll talk about some Q&A. So as people have questions about individual panelists' perspectives or other topics that anybody might be able to dig into specifically from their points of view, or questions about the politics, please put it in the Q&A. Joe, over to you.
Thank you very much. And I'll try to keep it short. We got a lot of really neat people attending this, and I'm sure they have a lot of really cool questions. And if you don't ask them, I'll come find you. No, just kidding. So hey, everyone, my name is Joseph Lorenzo Hall. I work for the Internet Society. The Internet Society is a global nonprofit working to make the internet bigger and stronger for everyone. At the Internet Society, we recognize that the internet, well, it's pretty special, right? I mean, just look at the work we could do today remotely that we weren't even able to do 5 to 10 years ago. You, me, we all did that using this amazing communication tool. I mean, we're doing it right now, right? We've started at the Internet Society to think about what specifically makes the Internet so special. We call this, in shorthand, the Internet way of networking. It's a way of thinking about the set of critical properties that undergird the Internet. We have so far identified about 5 of these critical properties, and with no surprise, intermediary liability plays a key role in at least 3 out of 5 of these, including providing a layered architecture with common services, relying on decentralized management and distributed routing to make decisions about where stuff goes, and ensuring that it's at most a general purpose network. That's what helps drive the innovation and the invention that happens on the internet. I'm not going to go further into these properties, but we'll be talking more about this at the Internet Society in coming months. And if you're interested in that, please stay tuned. But by supporting each of these properties and breathing life into them, we get the internet we get an internet primed for the kind of transformative change and invention that we've seen over the past 25 years. This sort of internet way of networking describes how independent networks voluntarily connect to one another to form a network of networks, and in turn to form the global internet. When this internet way of networking is under threat, so are all the opportunities it offers. And so when it comes to intermediary liability, it's the internet is a complex system of networks, and the complexity of the internet is something that regulators and policymakers really must increasingly understand before developing policies and laws that affect it. It's been relatively unchanged for about 25 years, and it's done everything from the early days of the internet, which wasn't terribly exciting, all the way to now, where so much depends on what we do and how the internet is structured. And in the early days, and back in 1995, the commercial internet, things were a bit simpler. We didn't have Facebook or Twitter. We had other things that you may have to look up, like CompuServe and AOL. The design was very similar to what it is today, and Section 230 reflected that design in a really important ways. It recognized that just like telephone service isn't responsible for the things you say over the phone, online services shouldn't be responsible for the things you post or send through their services. And to us at the Internet Society, internet liability means 3 things. The first 2 are sort of the proverbial shield and the sword that Ron Wyden calls the Section 231 of the co-authors of it. So, the shield is not being responsible for things that others say on your platform. And the sword is being able to make your chunk of the internet truly your own and curate it and garden it according to what you want it to be associated with your brand or your community or whatever it is. But the third is that it also creates certainty and predictability. It's really important. And if we want to preserve the internet's features like interoperability amongst all these crazy systems, generativity so that people can create things that create other things, the end-to-end principle, then we really must ensure that any intermediary liability framework reflects the internet's architecture. And here's the rub that we've learned all too well over the years. An intermediary liability regime needs to be technology aware by fully grasping the internet's architecture, and also technology neutral by not requiring any special technology for the internet to function. Now, when it comes to the executive order, the main problem, in our opinion, is something that Andy just hinted at, is that this executive order makes a fundamentally legal debate a partisan debate. Politicizing Section 230 could reverse years of predictability and could place the internet's vast potential, vast creativity fundamentally in jeopardy. The executive order also enacts a dangerous precedent both for the internet and for speech. Problem is that many of the provisions in the EO seem like what Daphne calls their atmospheric, politically driven questions that do not belong in the legal debate itself about the scope of intermediary liability protections. Conversations about the evolving scope of Section 230 are somewhat healthy. They're happening, you can't avoid them, but conversations shouldn't be as politically motivated as this is. Section 230 historically promotes innovation and creativity online, and by separating it from partisan politics, we can ensure that those kind of benefits continue. I also want to raise the flag of encryption here, another big part of what we do at the Internet Society, and specifically end-to-end strong encryption. As we see in Section 5 of the executive order, the working group established by the Attorney General will be going into great detail in terms of interrogating how online services make decisions of encryption here, another big part of what we do at the Internet Society, specifically And of course, as mentioned, Graham's Earn It bill would remove intermediary liability from any platform that offered strong end-to-end encryption. It's not what it says, but it's the effect. Happy to debate that. To the extent online service providers will have to start monitoring for and detecting certain kinds of content, that's going to make it impossible to offer certain kinds of end-to-end encrypted communications. Like everything we use, from ordering prescriptions online, making sure that it's confidential and the right amount and the right drugs, to the encrypted messengers so many people rely on to keep themselves safe from threats, big and small and remote and local. With that, I'll yield it back, and I'd love to have some great discussion. Thank you.
Excellent. Thank you, Joe, and thanks for helping provide a bit of context there for the importance of 230. I kind of have a question here for maybe Daphne and Evan, which is a little bit around the structure of the EO. Let's say the EO, gathers some steam politically. It's able to create an environment to say, this is actually the direction. We agree, Congress, that 230 should be reformed, and it should be reformed in the way that President Trump has outlined in the executive order. Is there a path for how Congress can do it in the way that Trump has envisioned, or is there something else that has to be done? Maybe you could talk about that in a kind of looking forward with the discussion around censorship in a legal context around the legislative branch.
Yeah, I'll jump in on that one. And I'm glad you brought this up, because I realized in my summary I forgot to mention the provision in the EO that says DOJ shall propose model legislation, and hopefully, and in the hopes that Congress would move forward with it. So this is a realistic scenario. So we actually have a lot of relevant precedent on this from the world of telecommunications, right? This is where we have seen this dynamic before, where there are private owners of really important communications channels, and there's a tension between the rights of those private owners to set their own editorial policies or use their property as they see fit, versus the rights of people who want to speak on those channels or access information on those channels. So we see broadcast regulation cases, cable regulation cases, et cetera. And the ones that are most relevant for a law like this would be cases about sort of must carry obligations, or the fairness doctrine, or laws that essentially said, hey, you private owner of a communications channel, you don't want to carry this content, but you have to, or you don't want to position it in this place on your product, your service, but you have to. And Congress has passed laws like that before. And the private communications owner channels have challenged them, saying we have a First Amendment right to set our own editorial policy. And there's probably the most important line of cases here are the Turner cases, where by a 5-4 margin, the court said, yeah, Congress can. You don't decide what to carry. Yeah. We're going to tell you.
We're going to kick it over to Evan here for just a second, Daphne.
Sounds good. I'll be quick. Basically, so to answer your direct question is, what does Congress do to make this legally viable or implement the changes that Trump seems to outline here? Two things to note. One, as I had already mentioned, the idea of making the FTC start using its Section 5 authority or clarifying its Section 5 authority when enforce policies that platforms use to moderate content wouldn't really be a legal change. They've already recognized that they have the authority, but it's you're limited in terms of how you can use that authority because it requires certain elements for there to be an unfair claim. There has to be basically a misrepresentation that changes a consumer's purchasing habits, which really isn't the case here. Same with directing states to pick up laws that do this. I mean, there's already a range of unfair and deceptive practices laws in the states. There's model legislation. Not every state has adopted it. It seems unlikely that states would be willing to. And even if they did, it's not clear that you'd be able to use it in the manner that Trump outlines in terms of enforcing certain political boundaries around speech. As to the question of re-injecting this good faith requirement in C2A, the trouble there is it sort of reflects a a misunderstanding of the jurisprudence here. I mean, most cases don't rely on this good faith argument because courts have interpreted C1 to provide the same sort of protections, but without this requirement of good faith. And the reason it's litigated is, I think, precisely the outcome we would see is to say, to examine good faith drastically increases costs for defendants. And that makes it basically impossible for smaller platforms to operate in this space. So if the policy change that you want to implement is to say any content moderation decisions must be made in good faith, and a court is allowed to test that, I don't see how you have small platforms. It's the reason why Senator Hawley's anti-conservative bias content moderation bill, which would have turned the FTC into basically a judge, a judicial body making sort of ex ante decisions about whether or not a platform has undertaken its content moderation practices in a politically neutral way, why that would be so problematic. It would require platforms to go before the FTC, spend a ton of money proving somehow that they're neutral, which would then allow them to have the protections of 230. All of this drastically increases the costs and ruins the value of Section 230 to the people who depend on it most.
Thanks, Evan. Daphne, did you want to start? Do you want to jump back in on when you were describing building internal?
I'll give it a try. Stop me if you can't hear me. But first, I'll say I wrote about this in an article called "Who Do You Sue?" It's pretty readable. It goes through all the cases where people try to sue platforms on a claim like this, and then all the old cases about telecoms providers and parades and shopping malls, and talks about how they intersect. But the bottom line is this would be a huge First Amendment fight. And the First Amendment right at the center of it would be the editorial rights of the platforms. And the composition of the court right now is not one that makes me think that the platforms would lose. We have the Justice Kennedy, who was a vote in favor of overriding private companies' rights in some of these cases, is gone. In his stead, we have Justice Kavanaugh, who, when he was on the DC circuit, spoke out very strongly, saying he thinks platforms do have the right in this case, in this situation, to exclude speech if they want to, and to set their own editorial policies. So I am not too confident of Congress's ability to do something that would survive that First Amendment challenge, for better or for worse.
So kind of building off that and taking into consideration the court cases and the challenges in the past, Emma, how do you think that a potential legislative endeavor that moves off of the EO may fare, the kind of criticism or the complaint that you've provided now?
Well, I have to say that that our complaint really isn't looking into the specifics of what the EO is proposing, rather than pointing to them as kind of all of these different elements that are building together as a whole to be this kind of coercive instrument. There are a lot of different ideas out there around Section 230, and I also see a question in our chat that's kind of related to this. The question from Javier Polero at Access about kind of the possibility for kind of the human rights conversation that's happening around the world to affect the regulatory debate. I think here in the US, to me, it all points back to what Daphne was just saying about the kind of the very high bar that the First Amendment will put on regulation that aims to either require companies to carry certain speech or to really kind of curtail their ability to exercise editorial discretion over speech that they host. There are a lot of discussions happening, though, around things like transparency and what I think of as more as the kind of due process or procedural elements to doing content moderation. So notice to users about what the rules are, opportunity to appeal, what happens to your speech on a platform. Again, in the US, anything relating to those kinds of features is still going to have to meet a high level of First Amendment scrutiny. If laws are drafted in a way that they seem intended to coerce services into disfavoring certain kinds of speech or to having to require or having to allow certain kinds of speech on their platforms, I think courts, to Daphne's point, are going to take a really close look at that kind of regulation. But I think Javier's question also underscores a really important point for the primarily US-based audience we have at this discussion, which is that the United States is far from the only country in the world who is considering questions of intermediary liability right now. And it's something for everyone in the US to understand the dynamics of what's happening, for example, in Europe, as they renegotiate their kind of core intermediary liability legal framework, which is the e-commerce directive. They're just now launching a process to create what will be called the Digital Services Act, which will be a new regulation in Europe that will cover everything we've talked about today and more, and is going to be based not under First Amendment principles, but under kind of European principles around protections of freedom of expression, which could include, and I know Daphne's written on this a lot too, these ideas about maybe sometimes platforms are obligated under the law to host people's speech. So I think the legal discussions of the law that governs platforms will only get more complicated, both in what we're talking about here in the US, but also as we see the many different legal frameworks that these companies operate in worldwide.
Thanks, Emma. Yeah, one of the points of this webinar is to try to look ahead to see how the social media EO may affect freedom of speech online and the internet in general over time. And so with that, I think we can kind of pivot a little bit to maybe an international perspective. Joe, I know that the Internet Society is a truly global nonprofit, and you specialize in some of the infrastructure there. Maybe you can ask a little bit about, or maybe you can talk a little bit about how the infrastructure piece may play in and a global perspective.
Yeah, so a lot of the discussion here focuses around content hosting, right? But that's not the only thing that Section 230 protects. Like, I mean, it still has to be, third-party stuff, but you can think of things as web caches, which are essentially boxes that you put on a network to increase the efficiency of the network. Basically, don't have to send something that you've already sent into that network before, right? And these are closely related to things called content distribution networks. And DNS is the same kind of thing. And you can imagine those folks, like, it's very different. The question is very different about whether or not these sort of more infrastructural providers should give services to one kind of thing or the other. I have very few answers to those questions, but I can tell you right now that's one of the problems here is seeing everyone as sort of someone that pushes content can often lump in people that provide certain kinds of infrastructural services and pipes in the same thing. And this is something that we've been looking at the Internet Society. And hope to have more to say, because there's not a whole lot written on infrastructure in the relevance of 230. And if there is, let me know so we don't duplicate the work.
Thanks, Joe. And Daphne, you spend a lot of time thinking through the EU's relevant laws and processes there. Do you have some insight into how the change in perspective in the United States may affect the global conversation?
Sure. So I've kind of had two kinds of feedback from people who are observing the EO internationally. One is from people who look at it and they're like, this is what happened in Venezuela when Chavez started yanking the licenses of radio stations he didn't like. People who see it through this lens of like a use of executive power outside of democratic process to set the rules for permissible public dialogue. So that's one framing, and right, that's a really scary framing. Another is more just like doctrinal in relation to what's going on in the EU. EU developments have been pretty complicated, but one important thing to look at is the hate speech code of conduct, which was an agreement negotiated between the European Commission, so a government body, and 4 big platforms, Microsoft, Twitter, Facebook, and YouTube, in which the 4 platforms agreed to use their terms of service to prohibit hate speech as defined by European law. But they're using their terms of service, so that's being exported to the rest of the world and enforced globally. And as a process matter, I've been very critical of that code of conduct for the same reason I'm critical of the executive order. It did not go through democratic processes. It did not set a rule that was amenable to challenge in courts by people who thought that the consequences were restricting their rights. So the EU does not have clean hands on this front either. But in terms of how the EO will intersect with that, well, now we have platforms that have committed to globally take things down that are illegal in the EU, but legal here. You know, things that are many people might consider hate speech colloquially, but that are First Amendment protected and not illegal in the US. And so are the platforms supposed to continue abiding by this commitment they've made in the EU to globally take down hateful speech, or to adjust that in light of the EO and, you know, tolerate more speech that they previously would have taken down, I think is one of many, many questions raised by the diverging approaches of EU regulators and the executive order.
That's an excellent point, Daphne. Evan, do you have a perspective on where the startups and small platforms may come in on the divergent tracks of international law?
Yeah, there is this weird trend, I think, where the U.S. is moving, at least if you believe the U.S. is moving towards the sense of, hands off, no moderation. You can't take down political speech for whatever reason. Whereas internationally, with UK online harms, NetsDG, all these different regimes that sort of mandate or sort of require or request removal of content that is sort of ambiguous, right? There's no easy way to look at it and say this is clearly hate speech, at least under US law, which puts platforms in a weird position. If you have international users, you now are in this position where you have to make very difficult judgment calls about what is and is not illegal, which actually just results in censorship effectively. We heard a story from a platform where they basically got into a position where they really couldn't host political speech anymore, because anytime there was some political speech on the platform, the folks representing the other political viewpoint would send takedown notices claiming that it was hate speech. And recognizing that the penalties were so enormous under German law, they just decided it's not worth it. We can't afford to have this on the site, so we have to remove it. Of course, that cuts directly contrary to sort of the motivating ethos, if there is one, of the EO, of saying platforms should be these open fora for discourse that is sort of uncontrolled by the sort of vagaries of the platform moderators' opinions. So you're kind of in this rock and a hard place, and it's unclear what platforms are supposed to do. I think more and more they're just getting to the point where they have to say, anything that looks problematic, we have to get rid of. It pops up in like the DMCA context. If there's something that could theoretically be copyright infringing, you take it down because the risks are simply too high. So what concerns me here is, the U.S. is moving towards this trend of, you can't moderate content, where the rest of the world seems to be moving in the opposite direction, and there's really no way to sort of square that circle from the platform perspective.
Yeah, that's an interesting point, and kind of draws into another discussion that is a little bit in the EO. And maybe this is a question for Daphne, but I know that the problem that a lot of people talk about when it comes to social media platforms isn't necessarily what they actually take down, but it's what they promote or disfavor, and a certain type of ranking or a certain type of preference for a certain type of speech or activity. Is that something that you see moving forward? Is that something that maybe isn't as much of a topic as far as the EO goes, or something that may not be the next step as far as FCC regulations come?
Well, it's mentioned in the EO, in that list at the end of things that AG Barr and the state AGs are going to think about. And it's all over the current legislative proposals in the EU. The Digital Services Act is full of discussions of regulating algorithmic ranking and algorithmic promotion. There's kind of a good conceptual hook here, and maybe even a good legal hook of saying, well, platforms aren't responsible for what their users say, but platforms are responsible for which things they choose to promote or demote among the things their users say. And platforms themselves have said, that's our speech. Our choices about what to promote and demote are attributable to us. But I worry that starting from there, I'm not sure you get to a legal outcome that works any better than what we have now. So first of all, if there were a law that regulated what speech platforms must promote and demote, that would also be a government regulation of speech. That would be the government coming in and telling platforms to favor or disfavor particular speech based on its content. So you don't get away from there being a big fat First Amendment question by shifting to talking about algorithmic ranking. And once you shift to that, there's a powerful question about what your goals are. And in Europe, you see people saying, we're going to regulate ranking so that it promotes pluralism and a diversity of voices. But you also see people saying, we're going to regulate it so it promotes truthful and accurate sources. Well, which of those two things are you going for? Or are you doing it for competition reasons? Or are you doing it for copyright reasons? Depending what your goals are, the outcome of algorithmic regulation looks really different. And to actually implement it, you would need a Federal Trade Commission or some equivalent entity with a massive engineering staff. I don't know how you understand a platform's algorithmic regulation and say whether it has met legal requirements without a degree of engineering resources that so far nobody has.
Emma?
And just to add to that, I mean, we've also had a lot of conversations within civil society, having nothing to do with regulation, about transparency from online platforms for many, many years, transparency in how they develop their content policies, how they apply them, and increasingly we're talking about exactly the same kinds of ranking and recommendation questions there. And so it's very reasonable for people to have questions about, what is it that companies are doing and how are they doing it? But exactly to Daphne's point, the conversation we need to have now is what are we actually asking? What are we actually looking for? And I think, as Daphne just pointed out, there are a lot of different voices calling for transparency into ranking algorithms or amplification algorithms, but maybe not all from the same perspective, or maybe not all with the same kind of values or interests that they want to see expressed in these algorithms. So that's something I think we need to be very upfront about in policy discussions around all of this. What are the actual values, incentives, and interests that people want to see platforms express? And then we can have that conversation about what's the right mechanism to get there. Is it possible to get there through the law, or will we run into the big fat First Amendment questions that Daphne was mentioning? Especially, and I can't underscore this enough in talking about regulation here in the US, regulation cannot require platforms to take action against lawful speech. The intermediary liability supposes that the underlying content is in some way illegal, and creating a new liability over how a service deals with lawful constitutionally protected speech almost kind of inherently has a fatal First Amendment flaw to it. So I think we need to be a lot more clear in our conversations here in the US and in Europe about what exactly are, whether it's regulators or civil society or companies themselves, what are we looking for in these conversations about wanting companies to do better or to understand more about what they're doing. We need to get really specific, because the details absolutely matter here.
Thanks, Emma. We are quickly approaching time. I'd like to open it up to our panelists for any closing remarks or any addendum for their previous statements. Hearing none, thank you so much, everyone. Thank you to the Internet Society for hosting. This was an excellent event. Thank you very much. This event has been recorded and will be available, I believe, on the Internet Society website. And with that, we will call it a day. Thank you very much for joining, everyone. Thank you to our panelists, and we'll all talk to you soon.
Thanks, everyone, for coming. Thanks for hosting or moderating, Andy.
No problem. Thanks, guys.